Good afternoon and welcome back for part 2 of the Protecting the Vote, Protecting Democracy webinar series, celebrating NAWL's 125th anniversary. Today, we're going to pick up right where we left off by talking about the current struggles of democracy in the United States. And specifically, we're focusing today on the use of intentional intimidation tactics to erode democracy, including hate crimes, voter threats, and political violence. My name is Carla Castello. I'm an attorney at Babst Calland, and I'll be moderating today. I'll briefly introduce our speakers, but their full bios are available on NAWL's webpage for this series. So first up, Leah Aden. Leah joins us from the Legal Defense Fund, where she serves as senior counsel. Also on our panel is Nadia Aziz. Nadia is the senior program director for the Fighting Hate and Bias program at the Leadership Conference on Civil and Human Rights. And our third panelist today is Gandhi. Ami is the Director of Strategic Initiatives and Midwest Voting Rights Program with the Chicago Lawyers Committee for Civil Rights. Welcome to each of you, and thank you for being here. If anyone has any questions throughout the course of this discussion, please feel free to pop them in the chat. We'll do our best to save some time at the end to address them. So we have a lot to talk about today. So I want to jump right in. For those of you who participated in the first session of this series, you'll recall that Carol Anderson talked to us a little bit about the impact of the landmark Supreme Court decision in Shelby County versus Holder. So Leah, this first question is coming over to you. You were part of LDF's litigation team in that case. For anyone who was not able to join us last time, can you give us a brief introduction of Shelby, but then talk to us about your involvement in the case and the impact of that decision?
Good afternoon, everybody. It's nice to see some friendly faces and to be able to have this conversation with you. Before we got on, I was saying that this is what we are all thinking about and experiencing in our everyday lives. So it's nice to continue the conversation with a new audience. So again, I'm Leah Aden. The funny thing about my involvement in the Shelby experience is that I was the most junior legal member of the team at the time, and that was in 2013. I supported the person who argued before the Supreme Court, Debo Adegbile from the Legal Defense Fund, one of the people who argued, and a cast of LDF attorneys that were really supported by tons of organizations, tons of institutions in support of Section 5 of the Voting Rights Act, which was at issue in that case. And my job was to comb the congressional record, which had as of the 2006 reauthorization, constituted about 15,000 of pages of evidence about the worst offending jurisdictions in our country. These are the states and localities that when a voting law was challenged successfully and struck down, another one would pop up. And so the Section 5, which was at issue, was about getting ahead and trying to prevent this whack-a-mole approach to challenging racial discrimination. And ultimately, the decision in 2013, June 25th, was a shameful decision that did not strike down Section 5 expressly, but struck down Section 4B of the Voting Rights Act, which identified certain states with the worst records of racial discrimination, who would scheme from one thing after the other, and would have required them to go to a 3-judge court in Washington, D.C., or the U.S. Department of Justice, and prove, and before implementing their voting laws, that they did not worsen the ability of not just Black voters, but Latino voters, API voters, Native American voters, did not worsen their ability to participate in the political process. It was considered the heart of the Voting Rights Act. When it was operative, it was the most successful at getting ahead of discrimination. And what we have seen in the years since is a real backsliding, the very backsliding that Section 5 would have prevented. Thousands of polling places changed, restrictions on photo ID, the adoption of photo ID laws, proof of citizenship laws, dilutive redistricting schemes, restrictions on absentee voting, restrictions on drop boxes. So everything that the record reflected would happen in these jurisdictions, and by jurisdictions, I'm referring to everywhere from Alabama to parts of California to parts of New York to parts of Michigan, to Florida, South Carolina, Texas, all the things that we surmise would happen without this preventative measure have subsequently happened. And in fact, not only have laws denied people the ability to participate, but we've also seen a real retrenchment and the great strides we had made towards reducing the racial disparities in registration and turnout to voting as well over the course of the last 10 plus years. So it's one of the probably worst decisions of the Supreme Court. You know, we would put it up there with the likes of the Plessy decisions and some of the other decisions that really set our democracy back, and really took away a sort of baseline system that we had in place to stop the sort of worst offenses of racial discrimination. And we continue to, you know, we'll talk later about the John Lewis Voting Rights Act, tried to urge Congress to respond to that decision and fix it. But the ramifications of it live with us today. And that's why I think we should all know about it and continue to try to correct it.
Thanks, Leah. And let's fast forward about a decade. So you also served as LDF's lead counsel and presented arguments in October of last year, 2023, for the Alexander versus South Carolina NAACP case. So can you tell us about that case as well and what's at stake as we await a decision from the Supreme Court?
Yes. So importantly, we in South Carolina, like in Alabama, Louisiana, and other parts of the country, I know Ami in Illinois, you know, lots of advocates after the census went to legislatures and said, when you redraw our lines, not just for Congress, but for our state houses, for our local governments, do not racially discriminate. Abide by the Constitution, abide by the Voting Rights Act, and try to adopt a map that is fair and that reflects the demographics that the census data reveals. In South Carolina and elsewhere, they did not heed our warnings. They did not adopt the maps that we thought comply with the law. And so in South Carolina, we had to sue because the legislature, with respect to its congressional map, which I'll focus on, we also sued around their house, state house map. But with respect to their congressional map, they took 30,000 Black voters from one coastal district anchored in Charleston and dumped them into a neighboring district. The panel ultimately found that they bleached 62% of Black Charlestonians out of one county. So even though they lived and worked in this one county, they were reassigned to another to have totally different representation than where they live alongside their neighbors. We were able to demonstrate with unrebutted expert testimony that the legislature didn't just target Democrats because this was partisan, and redistricting is heavily partisan, but that they focused on the heaviest Black precincts, not just Democratic leaning precincts. And so we were able to challenge that map as a racial gerrymander, and also a map that was designed to intentionally dilute the political power, the voting power of Black voters in South Carolina. That decision was appealed to the Supreme Court, and we are now pending a decision from the Supreme Court. But unfortunately, because the Supreme Court has taken so long in issuing a decision, South Carolina is starting to put in place that unconstitutional map for elections this year. This is the same map that they unconstitutionally would have used in 2022. This is now going to be potentially the second cycle that they'll use this unconstitutional map because of the delay of the Supreme Court. And why this case is important is because this is not unlike our work in Alabama to create a new majority minority district, or in Louisiana to create a new majority minority district. It's about what happens when Black voters or other voters of color are in the minority. Our Constitution still prohibits the excessive use of race without a compelling interest, even in those contexts. So even when you're a minority, you still have protections. And it's also important because, you know, the Supreme Court has allowed legislators to draw lines for purely partisan reasons. But it has been very clear that where you use race as the means to achieve party advantage, that can be constitutionally suspect. And this was a case where we proved that this was not solely about partisanship. Race was the driving factor, and racial groups were harmed in the development of these lines. And our Constitution is supposed to protect that. So that's why we're involved, and that's why it's important. And it's frankly a scheme that we've seen across the country when folks are like, we can do whatever we want because of the Supreme Court's inability to police partisan gerrymandering. They have then been manipulating racial minority voters across the country. And we thought it was important to challenge it, not just in South Carolina, but to continue to use the tools to say that is not acceptable under our constitutional scheme.
For that background, Leah, and for all the work you're doing to secure the right and access to vote for millions of Americans through all of these Supreme Court decisions. I want to turn things over to Nadia for a few minutes so we can talk specifically about how intentional intimidation tactics have been used and are still being used to disenfranchise voters. So Nadia, the Leadership Conference Education Fund issued a report in April of 2023 titled Cause for Concern 2024, The State of Hate. Can you tell us about that report and your involvement in preparing it?
Sure. Thank you so much for having me. The report Cause for Concern 2024, The State of Hate is actually the latest in a series of reports that the Leadership Conference started publishing back in the 90s. And in this report, we knew what would be coming in 2020 during the 2024 election because of what's happened specifically over the past 4 presidential election cycles. So we know that while hate crime data is notoriously underreported, the data that does exist shows trends. And one of those trends is that hate crimes increase during presidential election cycles. And so we specifically looked back at the 4 presidential election cycles, starting in 2008. And we kind of told the story about how, not only have hate crimes increased, but white supremacist activity also increased significantly during those same time periods. And of course, not all hate crimes are committed by white supremacists, but there tends to be a bit of a correlation there. So we started telling the story in 2008. We saw the election of our country's first Black president. It was a hugely momentous moment and celebratory moment for many. It also served as an organizing moment for white supremacists and white nationalists. Then we get to 2012 and, still responding to the electoral popularity of President Obama and the more robust social and economic policies. White nationalists and some media commentators spoke of the end of, quote, traditional America. And some of the white nationalist leaders kind of saw 2012 as their last chance to make their case to white America. Fast forward to 2016, and we all know what happened that year. But the 2016 election cycle really saw an amplification of organized hate groups by elected officials, candidates. They really brought the content to the broader American audience. And when candidate Trump announced his campaign in 2015, he immediately set the tone and sort of began fanning the flames of hate and emboldening white supremacists. So hate crimes have been on the rise since 2015. They have not returned to pre-2016 election cycle numbers. And they've actually, since 2015, the number of reported hate crimes have nearly doubled. So the most recent data from the FBI is from 2022, and it shows the highest number of reported hate crimes on record ever. And also one kind of disclaimer there, I've mentioned that hate crimes are notoriously underreported. Law enforcement agencies are not required to report hate crimes up to the FBI. It's completely voluntary. And while the number of reported hate crimes has increased, over the past 5 or so years, the number of law enforcement agencies that have been reporting hate crimes has decreased. So we have both trends are going in the wrong directions. 2020 election cycle, combine that with the COVID pandemic and the increase in hate targeting the Asian American communities, even though hate crimes had already been on the rise for a while, 2020 saw about a 13% jump in reported hate crimes. And that can be contributed to the racial justice protests of 2020. It can be contributed to the increase in anti-Asian hate as well. And all of these data points point to the fact that during elections, when there is more inflammatory, more divisive, more racist rhetoric being used, there's a parallel increase in hate that communities are experiencing on the ground. And so our report looked at these election cycles. And then we looked forward to the 2024 election cycle. And, kind of stated that the political climate, the current political climate in the country is such where you have state legislatures across the country that are seeking to ban books, whitewash history, limit curriculum. There's a huge wave of anti-LGBT laws across the country. Pair that with the fact that social media platforms have had waves of layoffs that impact their trust and safety teams and their teams that counter disinformation. All of this kind of creates a climate that is cause for concern going into the 2024 election. And so, we say we're not trying to freak everyone out, but we say that all of these factors kind of are contributing to a cycle that will at least be as bad as it has been in previous years unless we take action. And so the report also includes 3 to 4 recommendations as well.
Thanks, Nadia. And I mean, the data is striking and frankly alarming. And I think we'd love to hear a little bit about what those recommendations are from a high level, if you'll share them with us. But I just want to know, in your opinion, how do hate crimes and this uptick in hate crimes, how does that impact the democracy of our country?
Of course. So hate crimes undermine the very ideals of an inclusive democratic society. I probably should have started with the definition of a hate crime, but a hate crime is a crime against a person or property that's motivated in whole or in part by the perpetrator's bias against one of the protected categories in federal hate crime law, which is race, color, religion, national origin, gender identity, disability. And so hate crimes are viewed as message crimes. So while they may target an individual, it's actually impacting the entire community, and it's sending a message that a community is not welcome. And so research has shown that hate crimes actually, quote, hurt more. So there's not just physical or emotional or, kind of mental injuries that are experienced, but there's also a tendency to not engage in community and civic life if you're the victim of a hate crime. And that is essentially what perpetrators of hate want. And so one of our recommendations is for public officials and everyone to counter the message that hate crimes send and speak out against hate, because it really has shown to make a difference. And an example of that is after the September 11th terrorist attacks, hate crimes targeting Arabs, Muslims, and South Asian Americans skyrocketed. And just a few days after the attacks, President Bush actually spoke at a mosque and spoke out against hate. And you can see in the data that reported hate crimes started to decrease as well. So really, one of the most important things we can all do is speak out against hate. And that's one of the recommendations. I'm happy to jump into the others or wait until later, whatever you'd like.
Well, we can wait. I want to throw things over to Ami for a couple of minutes. But we will circle back to the other recommendations, Nadia. Thank you. So Ami, what intimidation tactics are you and your organization monitoring, and what tactics are you seeing that are aimed towards disenfranchising voters?
Thanks, Carla, and it's great to be with you all in this conversation where I'm already learning a lot and taking notes, hearing insights from other speakers. I'm Ami. I'm with Chicago Lawyers Committee for Civil Rights, and I lead our Midwest Voting Rights Program. And particularly with our more in-depth work at this time in Illinois and Indiana, we do observe that there is unfortunately voter intimidation in every election, big or small, whether it is a high-profile, nationally known election or a municipal primary. Voter intimidation does happen, unfortunately. It's not necessarily the experience of every voter or most voters, so I don't want to exaggerate that either. But even one incident is one too many, and the main takeaway that our voting rights team has is when, for example, we're supporting voters over the phone and in person in our election day work, we learned that intimidation shows up differently for different people, and their takeaway about what can feel intimidating and chilling and exclusionary at the polls can also depend on their personal characteristics and their life experience. And they can sometimes perceive that something was meant to or had the effect of being intimidating to them, that another person, one of our pro bono attorney volunteers or even our staff, may not have even picked up on some of the nuance there in how the intimidation could have happened. And so we really try to focus on that in our training, for example, in our voter protection training, and just in our own self-reflection on our staff in carrying out our legal work, that there can be instances of verbal harassment or physical violence, something that all of us here in this meeting would immediately recognize as being voter intimidation. There can be other actions taken that may be more in the eye of the beholder, when voters report being followed around or being improperly asked for ID, hearing conversation in the polling place, and sometimes not even totally being sure if it's someone who works there or bystander or fellow voter who may be talking about allegations of voter fraud, for example, in a way that can be unfairly scaring someone or singling someone out or casting suspicion on someone. We particularly know that this impacts voters of color and new citizen voters. We have observed, well, I have taken in a comment while waiting in line for voting, the message along the lines of "go back to where you came from." And you know, it can be taken different ways. Sometimes these things happen quickly, and in the blink of an eye, you're not quite sure what happened, and trying to make sense out of it. I have enough support and knowledge about it to follow through with voting, but I don't expect that it's necessarily for the same for other people who are taking in those sorts of comments or experiences. And unfortunately, we do have our voters who contact us and nonpartisan civic organizations who come to us for legal support, telling us about instances of police presence at the polls that, depending on the situation, can be intimidating. And especially in the Indiana side of our work, various reports of guns in and around the polling place. The policies around guns in Indiana being, I think the way to call it is a permitless carry state, which I don't really know what that term means. There's just a very little regulation of guns, and a lot of emphasis in the state policies on the rights of gun owners and manufacturers. So it does end up intersecting with people's experiences at the polls. And I want to mention another kind of example that's a bit different from these generalized sorts of conditions that I described, which can happen in a variety of different polling places and communities. But given our in-depth work partnering with people who are incarcerated and strengthening and expanding voting rights, I want to shine a light on the fact that the specific actions that can be intimidating to voters can also show up differently in settings where there is a connection to carceral system. So let me share a specific example. A lot of our work during elections relates to protecting the rights of eligible voters in pretrial detention. And even in the places that are the carceral settings where they're relatively speaking, the farthest ahead in protecting and ensuring voters' rights, the way that these spaces are designed inherently mean that there can be intimidating aspects, unfortunately. So, for example, having some voters be shackled during voting. These are eligible voters, you know, essentially being detained because of financial inability to pay bail, and predominantly Black and brown population, and disproportionately Black and brown population compared to the general population, having physical restraints during the process of voting in elections that they're eligible to vote in, and proximity between officers and voters, and just the inherent way that these carceral settings are set up can also be intimidating. Voters report being told comments like voting is a privilege, not a right. And, you know, if someone hears that in a situation where it took so many steps for them to even be able to gain access to that voting room, that can be chilling and exclusionary as well. And I say this not to shame the government officials who have been hard at work to even get this level of voter access in place, because that has not come automatically. It has not come easily. And some of these conditions I'm describing in the jail voting setting have gotten better over time. And I want to share that it requires constant vigilance, and it's a type of voter protection work. We look at it as part of our election protection work. And just before straying from this question, I do want to mention that how voter intimidation is addressed is so important. So I'm not here to just share scary stories of the dismal aspects of our voting system, but we also try to keep a keen eye on what can be done. Is there anything that can be done in these really heartbreaking situations? And so we train our volunteers on how to try to de-escalate situations when such tensions and intimidation are happening, how to work collaboratively with the government officials who hold the power in that situation, the people who are running the elections, and the people in the case of jail voting who are running the correctional institutions. And we just have really way slowed down that part of our training to just allow a lot more time and space to walk people through what these intimidating situations can look like and how can we respond in the moment that in a way that's helpful and ultimately that keeps in mind the safety and well-being of our own staff and pro bono volunteers and certainly voters as well. But that's not the typical way that voter intimidation could be addressed. And we often see rush to involve law enforcement when voter intimidation is alleged or observed. And our communities that we work with and that we're accountable to tell us that this is not necessarily fruitful as being the sole way or the first way that voter intimidation is addressed. And we know that that can depend on local dynamics and preferences. So I know it doesn't mean that we would never call law enforcement or call the police if there's an instance of voter intimidation, but just again to slow down the interactions as much as possible in the heat of the moment like that and work with people directly impacted by the intimidation to explore what could be a helpful next step.
Amy, I want to stay with you, but pivot slightly. Can you talk to us about ballot initiatives and specifically ballot initiatives concerning reproductive rights? We're hearing that there is unprecedented behavior on the part of public officials intending to block these types of initiatives, for example, refusing to engage in standard procedural steps. And we're also seeing harassment of volunteers who are out there seeking petition signatures. So is this consistent with what you're hearing and what you're seeing on the ground?
Yeah, I first want to give a plug for your continuing series about this, because my understanding is that you all will be continuing to explore this very important topic. And I'm grateful for that because I count myself as someone who's also trying to learn about this topic, given that there's a lot of variation in different states. And most of my experiences with states where community members cannot get very far in trying to enact change through ballot initiatives, unfortunately. So I'm learning about this as well. But basically, Carla, I first want to say my observation has been along the lines of what you're describing in terms of just all the roadblocks being put up when people are trying to use democratic processes. And I mean that in the nonpartisan use of the term, trying to use processes to move forward changes and protections of our rights. And it is very concerning. It's also not entirely new. Some of these are new iterations of long-standing problems and strategies used by people in power to try to block attempts at change. And so while we certainly have a concern when that intersects with people's reproductive rights, it also shows up in other aspects of our racial equity work. So even we very recently had a primary election in Illinois, and there was a ballot initiative relating to addressing homelessness. And it was a ballot initiative about a local real estate transfer tax. And there were so many legal shenanigans to try to even prevent votes for that referendum to be counted. And so I'm not even just talking about campaigning for or against, vote yes or no on this question, but to even just backing up several steps, prevent voters from even being able to have a say on that type of issue. And it leaves advocates frustrated and exhausted, whether it's relating to trying to protect our reproductive rights or other types of rights. And changing topics slightly, we've seen interconnections between threats to reproductive justice and voters seeing urgency around their voting rights and opportunities for civic engagement. And I especially want to uplift the ongoing threats and also advocacy going on in Indiana communities around this. And in the moments in 2022, when the Dobbs decision was leaked and then the decision was officially released, then when very soon afterward, a near total abortion ban was enacted in Indiana, at each of these different junctures, and these issues, of course, continue to play out, we heard from a voting rights perspective, we noticed these surges of community members being interested in getting more involved in our democracy and figuring out outlets for that. And we can't ignore that. Even though I'm not the foremost expert in reproductive justice, I learned from, a lot of others here and beyond this space on that note. But as a voting rights advocate, this is certainly noteworthy to me because it's coming up in terms of the intersections. And that doesn't always translate to voter turnout. It doesn't always translate to ballot initiatives even being a possible route. And it doesn't always translate to ballot initiatives getting passed. But it does mean that people are interested and maybe are going to continue to have the need for voter protection and their own ideas about the nuance of how people want to participate in our democracy. In reproductive justice actions in Indiana to this day, people frequently mention redistricting and gerrymandering and how the manipulated district lines are one of the reasons that we have the very restrictive social policies enacted into law that we do. So really appreciate this organization's leadership in provoking these conversations about these intersections.
Thanks, Ami. So let's all look forward a little bit, and I want to talk about the outlook as you all see it as we move into this election year. So Leah, I'm going to come back to you, but Nadia and Ami, if you have anything to add, please speak up. Leah, based on your work on voting rights and your knowledge of the Supreme Court, what do you think we can expect going forward with this court with respect to voting rights?
I'm going to start with the positive, which is just last year, the Supreme Court issued a to some very surprising decision in a case arising out of Alabama that LDF and ACLU and other advocates have pursued, which is to ensure more electoral opportunity for congressional and state legislative maps. And the case that reached the Supreme Court led to an affirmation of a panel decision that the state of Alabama had tried to suppress 30% of Black Alabamians into one of 7 congressional districts when it was possible to create at least 2 ability to elect districts. Not only did the Supreme Court surprisingly affirm that panel decision, but the opinion also has reaffirms the continued constitutionality of Section 2, which is not the provision that was at issue in 2013 in the Shelby County decision, but Section 2, which is the affirmative piece of the statute, which is where you can go into court after a law has been passed and try to challenge it for either having discriminatory results or a discriminatory purpose. For a long time, that provision, much like Section 5, has been chipped away by courts, and it was, we thought, at risk of being struck down or otherwise weakened by a case like the one out of Alabama. But instead, the majority of the court reaffirmed the vitality of that provision. It also reaffirmed that private plaintiffs have the ability to bring Section 2 lawsuits, because we've seen at least one lower court in a case out of Arkansas and going up through the a panel of the 8th Circuit say that only the U.S. Attorney General has the authority to bring private Voting Rights Act lawsuits, which goes against 50 years of precedent. So we have this good decision from the Supreme Court that has unleashed litigation all over the country at the congressional, state, and local level for school boards, county commissions, city councils, water districts, to create new opportunities for members to have a say on all of those elected bodies. So that's the positive. We were not expecting, not all of us were expecting that decision, and we got it. And now advocates are running with it to shore up the power that exists in communities. But at the same time, the Supreme Court has made up for some this so-called Purcell principle, where they have allowed a lot of election laws that other courts have found to be discriminatory, or they themselves have even affirmed to be discriminatory, to go into place because they're purportedly too close. The decisions are too close to an election to change them. And it's really such an affront, because our Constitution is supposed to say, like, one election too many under an unconstitutional or illegal map, you can't get that election back. People get elected, they start implementing policies around reproductive rights, around housing, around all the things, and you can't put the genie back in the bottle. But the court has allowed this to happen on far too many occasions, and there doesn't seem to be a stopping point to that. So this Purcell principle is something we should be on the lookout for. In 2021, the Supreme Court also issued a Brnovich decision out of Arizona, which has made it harder to challenge laws that have not a discriminatory purpose, but have a discriminatory result. So the Voting Rights Section 2 allows you to bring claims where significant communities of color are disproportionately harmed by bills, even if you can't prove that they were designed with that purpose. And they have ramped up the burden that advocates have to establish in order to prove those claims. And so that's why we see in Florida, in Georgia, in Texas, and elsewhere, the ability of, after the 2020 elections, them be able to restrict absentee voting, to be able to restrict drop boxes, to be able to prevent people from having water in line to vote, because it's just, even though they're harming thousands of voters, it's not significant enough under this Brnovich decision. So all of that is happening at the Supreme Court level, and at the same time, this is trickling down to certain federal appellate courts and certain trial courts to really make it just very difficult to uproot discrimination after the fact, which is why Section 5 and restoring it is so important. But at the same time, I've been heartened by a lot of trial courts that are in their authority, are looking at the evidence of discrimination, looking at the law and applying it as it exists, and finding discrimination across the country. And then what happens at the appellate level is what happens at the appellate level. But we're seeing enough courts do their job and call out, in the same way that we have documentation about intimidation, we have documentation that voter suppression is happening, whether intentionally or in results. And more people need to be doing their job of calling it out and making a record of it, so that we can get the type of legislation that is broader and that will sort of get at problems before we have to use the very long, expensive litigation process to try to attack them on the back end.
Thanks, Leah, for the background on the courts. Let's pivot a little bit to Congress. And you mentioned earlier the John Lewis Voting Rights Advancement Act. What are your thoughts on whether Congress will pass that act? And if it doesn't, does LDF have any other strategy for restoring the Voting Rights Act? And maybe just by way of background, if you could tell us a little bit about the John Lewis Voting Rights Advancement Act as part of your.
So I'm in the business of hope, I think, much like all of you, like where things take too long and things don't look immediately like they're going to be the way that we want them to be, but we believe that it's possible. And the John Lewis Voting Rights Act would directly respond to the 2013 Shelby County decision. It would create a new pre-clearance framework for identifying the places with the worst records, based upon a new formula, and require them to pre-screen their voting bills before they can be implemented. And again, this is every type of voting change. And so it really would do a lot of the work that we're having to do on the backside to stop measures before they're passed. It would also it would make clear that private plaintiffs have the right to bring litigation. It would respond to other decisions that the Supreme Court has issued, which have chipped away at the robustness of the Voting Rights Act. It has been reintroduced since 2013 in almost every congressional session, and there have been hearings around it, and there's been a record built to try to pass this legislation. So I remain optimistic, because I was just reminded that in Selma this year that there was a moment in history in the 1960s where we got not only the Civil Rights Act, not only the Voting Rights Act, but the Fair Housing Act, one after the other, and they transformed this country. So if that was possible then, I believe that there will be a moment in time where the advocacy, all the forms of advocacy will align and we will get this legislation. In the interim, LDF has rededicated itself to supporting states try to pass state Voting Rights Act. And most recently, New York and Connecticut have passed basically their own version of the Federal Voting Rights Act, requiring pre-clearance and other tools in order to get at changes to voting practices that will affect state elections. And we're seeing this pick up, and there be a campaign in states from Indiana, where Ami works, to Maryland, to Michigan, to Minnesota, to New Jersey. And California has long led in having a state's Voting Rights Act since the 1990s. And it's one of the reasons why there has been a plethora of representation, particularly of Black and Latino and API representatives, and those communities being represented in a lot of local bodies in California, local and state bodies, because they have had their own Voting Rights Act parallel to the Voting Rights Act for a long time. So we think that while we push for the John Lewis Voting Rights Act, states can be doing things on their own to have their own protections in place. And we urge folks to be encouraging their representatives to consider their own state Voting Rights Act if you don't already have one, or to pass one if you happen to live in a state where there's an active campaign happening right now. But I don't think we're ever going to give up, because if it was possible, and frankly, the Federal Voting Rights Act is considered the most successful piece of civil rights legislation we might have ever had, and it really changed the course of this country to be more democratic, then it's worth the continued fight. And we believe that there will be a time when it's possible for it to be passed again, just like it was over 4 different decades across various administrations. It can happen again in our lifetime as well. Thanks,
Leah. I mean, I'm learning so much from listening to all of you. So I just want to thank you. We're not done yet, but it's really great to hear about the work and an optimistic view of, like, we've been there before, we could get there again. So before so Nadia, I want to circle back to something that you said earlier. We were talking about the report and the recommendations. And I think now is a good time to talk about the other recommendations in the report as we kind of look forward at this election year. So can you talk to us about those recommendations?
Sure. 2 of the other recommendations that we include in the report are one, that social media platforms need to address the hate that festers online. They need to enforce their policies, they need to update their policies, and they need to really staff up their trust and safety teams to be able to actually address the enormity and the scope of the issue at hand. One of the things that we've seen in recent years over the course of the past 4 presidential elections is conspiracy theories that have just gone viral on platforms. Social media companies absolutely can and should do more to address that. These are conspiracy theories that have been behind some of the most deadly hate crimes in recent history. Another thing we are working on is to improve hate crime data. There was a bill introduced just a few weeks ago in the House. It's a bipartisan bill by Representatives Beyer and Bacon. And it's called the Improving Reporting to Prevent Hate Act. And this is legislation that, while reporting hate crime data to the FBI is not mandatory, this legislation would actually condition federal funding under the Safe Streets Act to credibly reporting hate crimes. And this would apply only to jurisdictions over 100,000 people, but we believe it would make a really positive impact in being able to understand what is happening to communities on the ground. And I wanted to really quickly, if possible, share a quick story. Leah said she's in the business of hope, and I'd like to think I'm also in the business of hope. One of the families I've had the privilege of working with is the family of Lieutenant Richard W. Collins III. Lieutenant Collins was a young man who had just been commissioned in the Army. He was just a couple days away from graduating from Bowie State, which is an HBCU in Maryland. And he was stabbed to death on the University of Maryland's campus in 2017 by a man who had publicly embraced white supremacy. He was in a white supremacist Facebook group, things like that. This family has experienced what I believe is some of the worst of America. But when you speak to them, it is so evident that they still believe in the best of it. They have served their country for 3 generations. They have 3 generations of military service in their family. They started a foundation in their son's honor to encourage service to community and country. And if you ask them, what can we do to counter hate? One of the first things they say is vote, to engage in civic life, to vote. And so while it's not specifically spelled out in the report, you know, one of our theories of change is we need to vote to get the country that a country that lives up to our ideals. So protecting the vote is also something hugely important to countering hate.
Thank you, Nadia, for sharing that. Ami, from your perspective, other than voting, what can attorneys and NAWL members do during this election year and the years to come to protect and advocate for the right to vote?
I'm sure my fellow speakers have ideas as well. I'll be happy to start us off and share that we are recruiting volunteers, particularly who can be focused on Illinois and Indiana during primary elections and the general election this year to join us for election protection. And people would be trained up to assist voters over the phone and in person. And so with an Indiana primary coming up in a few weeks, we are in the thick of election protection preparations. And if that's not the location or date that's relevant to some of the folks here, certainly we can use all the help we can get for November as well. And I know analogous efforts exist in other parts of the country too. And we couldn't do it without our pro bono volunteers. We're so pleased to be able to have a more mighty force of us when we join across attorneys and legal professionals and policy professionals of different professional backgrounds and different practice areas, but who are willing to spend some time, even in a bite-sized pro bono opportunity way, to assist voters. And for many voters, it makes the difference of whether they can vote in or not, and whether their vote is counted or not, if they can get assistance with the informational type questions that they have about, you know, should I be having to vote on a provisional ballot, or my polling place is not open on time, but I need to get to work. The whole range of things that we hear about through the 866 Our Vote hotline. And if people, even in the legal community and in our other respective networks, are sharing those sources among our networks, that would help a lot as well, to be sharing out the 866 Our Vote number and the companion lines for people who speak languages other than English. That will also help spread the word about a nonpartisan, credible resource that'll work for anywhere in the country, including during early voting. I mean, the hotline is active even when people have questions year round. So that's the plug I'll make to you, and want to ask my fellow panelists if you have calls to action as well.
John Lewis Voting Rights Act, urging not only you, but like people in your circle to encourage your representative to support it. See if you have a state's Voting Rights Act and see whether or not there is an appetite to build one. There's obviously the election protection work in every jurisdiction across the country around this election, but this is not the only election. There will be an election next year, an election next year. And I don't think we talked in depth about, you know, the shortage of poll workers because of all the intimidation and all of the mistreatment that we've seen in recent elections. And so, you know, for lawyers who maybe are less intimidated than the average person, considering how you might be involved as a poll official in one capacity or the other, while we have made a lot of strides in changing the lines to make them more fair at the congressional and state level, there is still so much local redistricting work to do for school boards and county commissions and water boards and state courts and DAs and all the other positions that require fair lines. And so we always encourage people to look in your community. Do your bodies reflect the community? Is there power being left on the table? Have you provided notice that there's another way for them to have redrawn the lines? I think that is something very important to do. and just really, registering and voting and getting as many people to try to participate, I think is still the direction that we need to be striving, because there is insufficient participation for a bevy of reasons in our country, and any work we can do to bring more young people into the political process, or more people with criminal backgrounds who can participate, even though there's so much misinformation about their ability to participate, just bringing more people to the table gets us further than where we are right now.
So, Nadia, if you have anything to add, please speak up. But I want to remind everyone watching, if you have any questions, please pop them in the chat. We have about 8 minutes left, so we can take a few questions if you put them in there. Otherwise, I want to just throw a general question out to all of you for any final thoughts, anything that you want the listeners to take with them as they move forward this year. Okay, well, we have not gotten any questions in the chat. So if there are no final thoughts from our panelists, I want to thank all of you for your time today and for all of your insights and for all of the work that you're doing out there to protect voting rights. And for those of you watching, please plan to join NAWL for the third part of the series on May 10th. In that session, we're going to talk about the systemic stripping of rights to wear away at the democratic fabric of our country. We'll talk about reproductive rights, transgender rights, voting rights, and by registering for this or the prior session, you are automatically registered for the May and June sessions. So we hope you'll join us. Also plan to join us in July 24th and 25th in Chicago for NAWL's annual meeting, where we'll hear from Stacey Abrams, and we'll continue the celebration of NAWL's 125th anniversary. So we have one question that has come in. The question is from Twanetta Weaver. She says, I live in Florida. Theoretically, are there opportunities to help with voter support in other states? Does anyone want to take that question before we wrap up?
Is the assumption behind that there's not plenty to do in Florida? Because I can definitely make the case that there is. Can't see the response. Oh, I think all the things that Ami and I talked about, and Nadia, about what can be done are applicable across the country in terms of opportunities to support. The election protection, I would note, is as I understand it, right, you can be in your office, you can be at home on a phone bank, so you could really theoretically help. Even if you live in a particular state, you could be helping a caller from Texas, right? I mean, it's national. But I would just put a soft plug for I have so many people that I love, and both as former clients or colleagues who are continuing to resist in Florida. This was a state that right around the 2000 election and even in the post 2010 election got a lot of resources and a lot of national support to try, because it was perceived as impacting the rest of the nation. And I think in this environment, that perception may or may not be the case, but there is still just an onslaught at every level of life in the state. And I think we need, and I know a lot of advocates who are based in the state are burnt out because they have been the direct recipients of the challenges, one thing after the other. So, I have always advocated both for organizations that are national or law firms that are national to pour back into those states and sort of just keep passing the baton of resistance, because we cannot cede what is happening there to folks who are relentless. I mean, this discrimination and this intimidation is relentless, but if as a woman-led organization for the better part of if we gave up in the face of the relentlessness of oppression, then none of us would be on this screen practicing as lawyers. And so we need to just pour back into places that seem like they're hopeless, because they're not. And Florida is a great example of that. Mississippi is a great example of that. Places that don't get all the resources, but that have so many challenges, and frankly a lot of the ideas for all of the suppression that then permeates and flows out to the rest of the country, they emanate from the places where we don't pay the most attention, right? So we see the plethora of the ID laws or the reproductive rights in the states where people are like, I can get away with this, they're poor, they don't, no one's paying attention to them. That's where the seeds of the hate begin, and then it is the cancer that spreads to the rest of the country. And so even if it's not where you live, we should be doing something to help our fellow neighbors and friends and advocates in other places. And it's tiring and exhausting, but we have to be as relentless as the people who foment hate and exclusion. We have to be as summons the energy to be as relentless as they are for good.
We have about 3 more minutes, so I think we have time for one more question. This one came in from Karen Richardson. She said, this fight can feel like eating an elephant. Should we prioritize, in quotes, purple states in the presidential election year, or start where things are most dire?
I'm not going to attempt to take anything away from purple states, but as someone who works mostly in a blue state and separately a red state, I can say that I see a lot of hope and promise when there are community-led initiatives where people closest to the issues of disenfranchisement, for example, are driving the strategy about how they think it can be fixed, including with support from lawyers. But we all know lawyers are not always a solution to everything, but if we can support a community-led strategy, I see a lot of promise in that, and that can exist outside of purple states as well. So that's how I kind of discern how should I spend my energy in these very difficult, challenging, demoralizing times, but leave it to others to weigh in too.
Go ahead, Leah. Do you have anything to add?
Well, everyone should be mission driven. I can say for the Legal Defense Fund, we work because our mission is to advance the rights of Black Americans, which has derivative impact on all people in this country. We go where our communities are, and that is not driven by any particular moment in time or any particular outcome, but where are the needs of the community. But there are folks who are focused on particular jurisdictions where they have analyzed and think that they will change the outcome for all of us. That may be where you feel led to go, but I know as an organization like ours, for the reasons that I explained before, that the underlying conditions don't change if we are never addressing the underlying conditions. And a lot of those underlying conditions are not happening in any particular place. They are either nationwide problems, or they're happening in the places that have the most challenges, the most under-resourced. And so I think I have chosen to spend my time in those types of places, even if they are not the ones that are always going to be on the news, or the ones that are going to be always outcome determinative in the short term, because but there's something to do for everyone, I guess I would just say, and we should all just be doing something and encouraging everyone in our network to please be doing something.
I can't think of a better way to end this session and our discussion. So I hope everyone enjoyed the discussion today. Thank you to each of you, Leah, Nadia, and Ami, for talking to us. And again, a plug for the next May and June sessions of this webinar series, the July meeting. We hope you'll all join us, and thank you for spending your time with us this afternoon.